the conviction, place you on probation, set terms and conditions, and then if you complied at the end of the probationary term, the case would be dismissed. I just explained I'm no longer willing to do that based on the fact that you didn't show up here for about 14, 15 months. You had numerous bond violations. Your lawyer is telling me that you understand and agree that the case will not be taken under 769.4A now. That is, that you will be sentenced on this case now, and the conviction will enter now. Do you understand that?
Yes, Your Honor.
Do you agree to that?
Yes, Your Honor.
All right, so I don't see a need to take the plea again. I trust you agree, Mr. Carmen.
I would agree, Your Honor, for sure.
All right, so I'll just indicate parties agreed and understood. Case will not be taken under 769.4A. Okay, with that, have you had a chance to review the report? Are there any material additions, corrections, and deletions?
Your Honor, yes, I have, and no, there are not. Just want the court to be aware that my client is currently prescribed medications for his mental health. He does a Vivitrol shot to combat, substance abuse cravings. Takes Wellbutrin and Effexor. So he's getting treatment for his mental health as well, Your Honor. And that would continue if he's to proceed to Oakdale, as is his plan. His mom is his legal guardian. He indicates to me that they've had a very good relationship since after this incident. He, in last year, in January through May, was doing rehab at Oakdale, as well as had a stint in, I believe, the mental health ward of the hospital. And after he got out, his mother helped him to secure housing. So after he was out of rehab. So they do have a good relationship now. He wants to just proceed to rehab and just to get all the help he needs for substance abuse and just to ensure none of this ever happens again. And
well, I want you to understand, and I hope I made this clear, my tendency is to simply send him to the medical unit of the Wayne County Jail and let him get mental health treatment. I believe that that's what he needs. So,
Your Honor, he disagrees, and
Please, Your Honor. Please, not that, Your Honor.
Mr. Liberty, will you stop interrupting? I didn't ask you anything yet. Do you want to say something else first, Mr. Carmen?
Your Honor, just thinking his mom is his legal guardian. It sounds like she is on board with him going to rehab, specifically at Oakdale. That's been their plan.
Well, you read all these letters she sent a year ago, right?
I read the one from December of 23.
Right.
Please, gosh.
Mr. Liberty, stop. He needs mental health treatment more than he needs substance abuse treatment, to be honest with you.
Mr. Liberty, if you went to Oakdale, what mental health treatment options would you have there?
So I'm already seeing a counselor 2 times a week via Zoom with Hygera, which is the same it's the same company that runs Oakdale. It's out of Lincoln Park. I have a doctor assigned to me. I'm taking medication. I'm attending all meetings. I'm taking the shot. I'm ready to get my life back on track. I'm ready to go to Oakdale because last time I had over 100. I had like 117 days clean. It's a very good environment. There's meetings for 12 hours a day. It's my mom. That's what my mom told me the other day on the phone. So, 2 days ago.
You still have those other cases pending, right?
What other cases, sir?
You still have the case. Hey, slow down.
Okay.
Let me finish.
Okay.
You still have the assault-resistant obstructing officer.
It's over with.
And would you please stop interrupting me, sir? And you have the flee and elude 4th degree, right?
May I speak? So I just the obstructing the arrest or whatever, that one's dropped. That one, they already dropped that. They dropped that last week. And then they're about to send me on, they, for the fleeing and looting, they're gonna drop that to a misdemeanor. They just told me the other day, my attorney came here. And he said that I was gonna be going to Oakdale on a tether in lieu of jail time for that. And like I mentioned, my mom, I just talked to her 2 days ago.
Stop.
I'm
I don't want
sorry.
to hear about your mom right now. Do you have a plea agreement? When are you going back to court on that case?
March 5th.
Well, March 5th is 7 weeks away. They're not taking you over to Oakdale now.
They said that they want me to Oakdale. They said that they had me on a tether on Monday. They had me on a tether the same day that I saw you last week. They had me on a tether going to Oakdale. They had me in the tether department going to Oakdale, sir. They have a bed available. I just want to get my life on track. I just want to go back and get clean, sir.
You don't want to, you don't, I'm not so sure about that. You don't want to be in the Wayne County Jail.
I want to get clean, sir.
Mr. Liberty, if you wanted to get clean, you would have come in and seen me a year ago. If you wanted to get clean, you would have shown up for your tickets that you've had elsewhere. California, you got a drunk driving, you never showed up from 2022. Please don't tell me that. You don't want to be in jail, I get it. Nobody wants to be in jail for the most part. I haven't yet to have anybody come in here. Well, I shouldn't say that. Twice a year, I get somebody tell me they don't want to do probation, send me to jail. But overwhelmingly, the 99% do not want to go to jail. I feel like I need some more information on this. Let's call in Jessica a second, please. They're not taking you over to Oakdale before the plea. I can tell you that.
Excuse me, Your Honor. They told me that they want me in Oakdale on a tether, sir. They told me that. They were going to send me, they were on board with that last week on Monday, sir. They want me to get, that's what the judge in Romulus said. That's what the judge in Romulus told me. Specifically, he said, I'm going to get you a bed, I'm going to get you a tether and send you directly to Oakdale from the jail. I'm not just trying to get out of jail, sir. Oakdale is what I need. Treatment is what I need. 100%. I need substance abuse treatment.
All right. Okay. Don't tell me what you need and don't need. You need a lot of things. Your name. So here's what I think I'm going to do. He's telling me, I'm not quite following it all. It sounds like something was reduced to a misdemeanor.
From when I looked online, he's scheduled for a pre-trial exam on those new felony charges on February 5th. So that hasn't been addressed yet. They're still felonies.
He's saying.
They're scheduled for a prelim. I did check online.
You haven't had a preliminary exam yet, right, Mr. Liberty?
I don't know. I'm not sure. But I know this. I know this. They put me on a tether on Monday, this past Monday, right after we got out of court. Right after I got out of court with you. The judge agreed to send me to Oakdale on a tether.
All right. Okay. I'm going to adjourn the sentencing 1 week. Will you call over to 34 and see what you can find?
Oh my God.
Listen. Mr. Liberty, just settle down. I need to find out what is going on here. January 21. I assure you I'm not your enemy here. I'm trying to figure out what the best course of action is for you. Just relax.
My mom, listen, Your Honor, my mom sent a whole email to Jessica. She sent it 2 days ago. My mom wants me in rehab.
I'll tell you what, Mr. Liberty, Mr. Liberty?
Whatever,
An
man.
email from,
So I got an email from his mother. It doesn't account for the whole time he's been missing, but she claims that from February 5th of 2024 to April 8th of 2024, he was in Stonecrest Mental Hospital downtown.
right.
And then from April 8th to May 10th of 2024, he was at the Oakdale Rehabilitation Center in Canton.
From what day? The last one is
The
April.
last one was April 8th to May 10th. So overall, it was from February 5th of 2024 to May 10th of 2024. He was in some kind of facility.
I wasn't trying to avoid you, Your Honor.
All right, okay. Okay.
I just want to get clean.
I have all these other letters here. And I feel like I want you to find out a little bit more. I don't know where I want to send them. I think he's got, I'm going to adjourn it 1 week until 8:45 on the 21st. I can assure you I will move on this then, Mr. Liberty. I want to make sure we're doing the right thing.
So you're gonna put me in, are you gonna put me in rehab, or are you gonna keep me here and put me in a mental ward where it's gonna destroy my mind? You can't just let me go, you can't just let my mom, those are old letters from last year. My mom and I have a great relationship right now.
You better.
She detailed everything in the letters to her 2 days ago.
Listen.
She wants me to go to rehab. You're gonna keep me in here for another week? I'm gonna lose my mind, dude. Do you know that they're squirting, they squirted, 20 of them surrounded me and they squirted cleaner in my eye the other day. I'm losing my mind in here.
Settle down. Settle down.
It's fucking unbelievable, man.
Mr.
You're
Liberty.
unbelievable.
Mr. Liberty, stop talking.
Let me talk to you and Ms. O'Donnell for a second. Then Chambers, go off the record. Mr. Liberty,
Yes, sir.
I'm going to caution you. I'm calling your case. Don't start getting lippy with me again. You got it?
Yes, Your Honor.
You got it?
You're in charge.
Anthony Eli Liberty, 23T720712. Mr. Carmen, your name.
Michael A. Carmen, P73824, on behalf of the defendant, Your Honor.
All right. Mr. Liberty, your name?
Anthony Liberty, Your Honor.
All right. Okay, I got it. So your client, we've gone back and forth. It's going to be taken under 7694A. Just the probation officer, Ms. O'Donnell, made some calls, found out that he was given a personal bond, but he has to have a tether put on, and then he was going to go over to Oakdale as a condition of his bond. So I don't know how he's going to go about getting that, when maybe he can call his mother and figure something out.
The tether department.
Also, hang on,
Sorry.
Mr. Liberty.
Okay. Yes,
Do
sir.
not interrupt me again. You got it?
Yes, sir. I'm sorry.
Maybe house arrest can come over there, but at any rate, I'm prepared to sentence. I'll listen to anything else you have to say. I believe you already said everything in the report was accurate, correct?
Correct, Your Honor.
Anything you want to tell me?
Your Honor, nothing further other than Mr. Liberty and his mother have a good working relationship now. I know the court has reviewed her latest correspondences, would ask that the court consider, in lieu of any jail sentence, just term of probation, and that he be ordered to attend Oakdale Rehab as part of that probation.
All right.
Thank you,
Anything
God.
you want to say, Mr. Liberty?
There's a couple of things I want to say. For one, I'm from Trenton, and my family it's not that it's not going to be redundant. It won't be redundant. I want to let you know that I have the utmost respect for you, Your Honor. Okay, my mom and I have a great relationship now. I'm just looking to go. I'm not trying to get out of jail. I'm trying to get my life back together, and I'll never pick up ever again. After this, I mean, I've been in trouble a couple times in my life, but the longest I ever spent in jail was 8 or 9 days. And I've been in here for almost 30, and it's been hell on earth. So this is a huge wake-up call, and I want to thank you from the bottom of my heart, and you will never see me again. And if you have to see me, I'll be there. I will never skip another court date in your district or any other district ever again. Thank you. I appreciate you. Thank you, God.
12 months probation.
Oh, thank you, God.
You cannot leave the state without the consent of the court or violate any law. You must appear in court appear to the probation department as directed. Lisa, I want to make sure we take out all the bond conditions, all those bond conditions now we are going to take out. You're not to possess firearms. You're not to possess dangerous weapons. You're not to have any assaultive, abusive, or intimidating behavior toward the victim, Gina DePonio. But I will let you have contact.
I love her to death.
I'm going to go. Please don't interrupt me again.
Okay. All right.
I'm going to order fines 100, costs 200, 75 victims' rights fee, $50 justice assessment. So fines and costs are 4 1/4. Probation fees are $240 for 665. Screening fees 60 for 725. Attorney fees of 40. Your total 765. Here's the big thing.
Yes, sir.
No alcohol. Just let me finish. No alcohol, no illegal drugs, no marijuana. If probation tells you to, you're to submit the chemical testing on their demand. Okay? Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to indicate to you that since you've been in custody, it appears since January the 6th, correct? Is that about right, Mr. Carmen?
My understanding, Your Honor.
December 20th.
Your Honor, I can look for you.
December 20th.
Let me look, Your Honor.
I came over here, Your Honor, on December 20th.
You were arraigned by me on January 6th.
Yes, sir.
Okay, you were dealing with the other case.
Yes,
I'm
sir.
giving you credit from 1 day from the arrest. I'm giving you credit for,
Your Honor, Mr. Liberty arrived at the Wayne County Jail on December 20th, as he said.
Thank you.
I'm not giving him credit on this case. He wasn't arraigned on this case. He's got credit that was dealing with the felony. I'm giving you 9 days credit. You are to successfully complete attend an inpatient treatment program and successfully complete a substance abuse mental health treatment program at Oakdale Recovery. Now, the key, so you have to go to that program. You leave the program before we get a letter saying that you successfully completed. I'm going to give you every single day I can give you. Do you understand that?
Yes, Your Honor.
If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I'm going to say you can pay your fines at the rate of $50 bi-weekly, and I will not start that until April the 1st.
Thank
April
you.
the 1st, every other week, you pay $50. If you need more time, you can come in here and talk to me, and I'll give you an extension. The
Thank
big
you.
thing is he's got an Mr. Liberty, will you let me finish, please? The big thing, he's got an overlap. Apparently, Judge Oakley ordered a tether and wanted him to go to Oakdale, but so somehow he's going to have to get a tether on there, and hopefully he can take care of that, and then he can be taken over to Oakdale. Okay, so any questions, counsel?
None, Your Honor.
Any questions, Mr. Liberty?
No, sir. Thank you so much. I'll never let you down.
I know. Well, you're going to let yourself down. You're going to end up in prison or jail if you keep up on this nonsense. I'm just telling you.
Doug?
Yeah.
Is Wayne County gonna handle the tether, or do I need to contact house arrest?
How are you guys going to handle that, deputy? Are you going to contact house arrest or?
So if you're ordering, you said Oakdale, I believe, inpatient treatment at Oakdale?
Correct.
So what'll end up happening is, since he has a tether ordered on the other case, I'm gonna take him and I'm gonna screen him by D-Wing. They'll fund the treatment, and then I will set it up with, the tether unit to get him transferred out. He will be picked up from the jail directly and go straight to treatment.
Perfect. All right, thank you. Good luck, Mr. Liberty. Thank you.
Thank you. Holy.
Have a good day, Your Honor.
Thanks a lot, Deputy. Michelle Anise Ellington.
All right, that guy over there was definitely a lot of energy. He's definitely going to give Oakdale a run for their money. Just imagine being the mom in that situation. I'm saying that's a grown man. He's balding. You know, he's living his life, and she's still having to take care of him like a 10-year-old. So that's. I think she's the one I feel most sympathetic for, because he's locked up for tickets. They didn't say what tickets it was, but being locked up for tickets and ended up in all that is certainly a lot more work. A lot of folks mentioning what happened in Antioch, Tennessee today. I've been seeing a little bit of it on the news. I get to the point I don't even trust the news anymore, but it's horribly sad. I lived in Murfreesboro, Tennessee for I think a little over 3 years, and Antioch was just right down the road. So it's really sad to, sometimes that stuff hits a little harder if you know the area. So let's go. We got to look at I'm gonna play the Judge Ballard run from last night that I never got to. Let's get to that one.
I really don't. I would like proper representation to help.
Well, but then and I'm not trying to sound callous. If you wanted proper representation, you need to contact either legal aid or the other types of legal assistance center. But this matter has been on the docket, and we're not adjourning this at this point in time because you showed up here today without representation. I can't provide that representation for you. I'm not allowed to do that. So I'm now asking if you have any questions of this individual pertaining to these exhibits.
I mean, yes, I do, but I feel like it's not going to get addressed anyways because I have no proof with me. I have no nothing.
Do you have any questions?
I mean, like I said, we have already discussed so many of these things, and she's saying we haven't, and we have. I have no proof of that. I have no proof. Her word against mine.
Well, right now, she's sworn to tell the truth, and so if you have questions you'd like to ask, you can ask her under oath, and then she will give her answer, and you can ask your next question, and then I'll be able to swear you in, and you can tell your statement under oath. But right now, I can't give you further legal advice, ma'am.
There's no way we can adjourn this so I can seek legal representation. I have been trying to get it for the last couple court hearings, and I've been in a room with a conference room, and I didn't know what to do.
Well, but ma'am, see, if you don't know what to do, here it is. If you wanted to seek legal assistance, contacting legal aid or legal assistance center or even inquiring of attorneys, those are things that are well within your and obviously something that would be, probably recommended if you didn't understand what you were doing. But rather than that, we find ourselves here in trial today. And now you're asking for that. That's not going to happen. We're in trial right now.
Because I didn't know what was going to happen this way. I had no clue. I have no idea.
All right. Well, I'm sorry that that's how you decided to treat today's notice. But all right. Any questions?
Please, Heather, please just let me get this baby out of me and finish off the lease until April. I will be out by April 25th, the court date the date that I'm supposed to be out. Let me get this baby out of me, please. It is just driving me crazy. I have a bad hip. My grandma just got diagnosed with stage 4 cancer. I lost my mom back in June. I am falling apart. And I feel like the violations we have addressed, I have addressed each and every one of them. I have Shelby's help a lot. Yes, I do. She might have overstayed her 14 days. I understand that. But I am by myself. That's all. That's it.
Have the violations been addressed? I guess I'm gonna just pull a question out of that statement. She's indicated that she has addressed the violations.
No, she has not.
What violations are yet to be addressed?
Any of them.
All right. Any other questions? All right. Anything further from this witness?
Nothing further, Your Honor. Well, actually, Your Honor, I will just, we will be seeking a judgment today for the 10 days, but I will ask my client, Ms. Russell, are you willing to give any time beyond the January 16th date, which is the statutory minimum?
No.
All right. I would, okay, that kind of goes to the judgment timeframe, but anything else of this witness?
Nothing further, Your Honor.
You may step down.
Thank you, sir.
Any other witnesses?
No, Your Honor.
All right. Do you wish to testify yourself?
I don't even know what that means.
Well, it means that I would swear you in, and then you would have to give your side of the story that you believe would give you the right to be there longer and to refute these matters. I mean, other than that,
I mean, if, I don't even know if it would help. Like I said, I gave my side. I'm just asking for.
ma'am, if you're asking to testify, I need to swear you in first.
Sure,
You swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Very good. Go ahead.
Me.
Yeah.
I'm like I said, I'm just asking for a little bit more time. Each one of these, I feel like we have addressed. Like I said, the first one, that was my mother. She passed away back in June. The autopsy shows that it was just, she'd been sick her whole life. The Narcan was because of her history, but it didn't do anything because she did not overdose. She was pretty much dead before the police even had gotten there. She pretty much took her last breath right in my arms before they arrived. With my brother, we discussed this in her office and talked about it. She actually just kind of wished me the best with him. The unauthorized was Shelby Grauman. Shelby Grauman she has stayed there. I watch her kids here and there. Yes, I do. It's just really her helping me lately because it's been really hard. I can't barely get around anywhere with anybody in my apartment. The stuff on the balcony, I had that stuff out there the whole time since I moved in and never realized it, even until she come around the back and said something. The very next day, I had them gone in the Jeep that I was driving and had that taken out and moved. And we had discussed it. I don't remember what infraction it was, but we had discussed one of the infractions. It's just like we've had one of the infractions and then my brother's stuff happened. We went in her office to discuss it. And then I got the new vehicle and she called me and said, can you come get the new sticker for your new car? Like we had these issues and then everything's okay when I go talk to her. And there's been so much tension and I've been going through a bunch of stuff that I just haven't went and discussed anything with her because she makes me feel uncomfortable. But I have addressed each and every one of these. Like I said, maintaining the sanitary, the apartment, she had sent me a letter saying she was gonna come back and do another inspection and I had to have everything taken care of. She came back and did that inspection and I had everything addressed. I had everything that to a T, everything that she would want done. It's just, I feel like these infractions, I feel like I'm not doing anything seriously wrong. I know they're infractions and I know some of these are against the rules, but like I said, I've addressed them all with her. I'm just trying to get this pregnancy done. I don't want to be there any more than she don't want me there. I have nowhere to go. I have checked my options like I said, I lost my mother, my grandmother, I'm losing her by the day. I have, right now, I have nothing, I have nowhere to go right now, I'm just trying to get my stuff, my head clear, I just want the baby out of me, and then in April, I'm fine, I'm gone. I have a younger child that'll be a year and 10 months, or 10 days. I just have a lot going on right now, and I don't mind discussing stuff with her, I don't mind talking to her and keeping up with her, but she, like I said, she makes me feel uncomfortable, and like I'm doing everything wrong. And I'm just trying to maintain being a mom, a single mom, and trying to take care of stuff the way I feel like I'm supposed to, and I feel like it's not ever good enough for her. But, I mean, I don't know, I wish I would've came here with, like I said, legal representation, but there's just been a lot going on. That's all.
Do you have any questions?
No, Your Honor, sounds to me that I haven't heard any valid legal,
Well, she's in, there's some legal basis there. She's indicated that she's addressed many of these issues, like she's cleaned it up after in the sanitary aspect of it. And I do look at the indications there, and there's certainly not, I mean, and I can understand getting a warning pertaining to them, but certainly that doesn't appear to be, a significant health concern or worrisome for the community, but and also would be things that would be fairly easily addressed, putting the clothes away and washing the dishes. So I don't know. She's indicated that she has addressed that. She's also indicated that she addressed issues out being placed out on the patio. Once after readily already admitted, she did make this statement that that they were there for extended period of time until she was advised that they're not supposed to be there, and then she took them in. So I don't know. Is that a significant violation? I don't know. But there are defenses.
the defenses to some, but not all, potentially, Your Honor. But I've heard her admitting to, the violations, but I don't have any further questions for the defendant.
All right. Then any other witnesses? All right. So let's have argument then.
Your Honor,
Well, I guess we can center the argument on what is the critical nature of just being 10 days?
Your Honor.
Because I'm not inclined.
Statutorily speaking, Your Honor, this is a termination of tenancy, and it could be based off of one lease violation or several lease violations. We have presented before the court today these several lease violations that have been taken place since this tenancy and since the date of this hearing or this case before the court. My client indicated that there hasn't been anything. She hasn't written. Excuse me, I'm misrepresented. She hasn't written anything up because of this pending case. But you don't need one major violation. Several violations is enough to under the law to request a 10 days.
I don't disagree that there's violations.
There's a history of activity on the property that has put some of the tenants here the tenants are concerned for their safety, and my client sometimes the landlord-tenant relationship has ended. And I think that this is one of those times where, it's time for both parties to part ways. And so we're not authorized to.
Parties are, I don't disagree with that. And it sounds like that is indeed the case here. My question is, why does it need to be in 10 days? And why couldn't we do it, say, on the 25th? That gives you plenty of time to get the place situated for anyone for a February rental.
That would have been my next question. That was part of my question when she was on the record.
Yes, that's why I understand. I know you tried that. So, but that's why I figured I'd try it. So there we are.
I appreciate that, Your Honor. It is my My client has indicated clearly
Okay.
that she has no problem giving more than beyond the 10 days. However, I just think that any additional month would prejudice my client, because then we're talking about,
No, I'm not talking about going into another rental cycle timeframe. That's why I'm saying if we get it on the 25th, you can be out on the 25th. Gives her an opportunity to get the place cleaned up and get it back online for February. It gives you significantly more time than the 10 days. It's as far as I can stretch. I'm actually already stretching more than I probably should. But
the 25th, Your Honor, is a Saturday.
I wanted to do a Sunday then. The 26th, I guess. So at the end of the day, at the end of that weekend, the 26th, you need to be gone.
My
So
client,
I'm giving you another, essentially, it's another 10 days beyond that. What?
I have nowhere to go.
All right, well, you're gonna need to seek resources. But right now, you have not given me a basis that can provide me the wiggle room to keep you there.
I just feel like all the violations have been addressed. I feel like that's what I feel. I feel like I'm not doing anything against the law. I'm not doing anything like wrong, and everything that she has, and everything that we have discussed, like every little violation we have addressed. I guess I don't know her main reason for wanting me out when I'm doing so wrong that she wants me out. I'm so quiet. It's just me and my kid. Like, I have other kids that come in, but I see kids running around there all the time. And I don't say anything because they are children. I don't see the problem with kids running around there, even if they're not mine. I don't have a problem with anyone there. I have talked to a couple of my neighbors. I'm really good friends with one of my neighbors. The other girl I went to school with. I mean, I've addressed it. I've asked other neighbors what's so wrong. And they say there's nothing. They don't know what. And that's every one of my neighbors that lives next to me. I just don't know what her main specific reason is. She gets rent because I go through HUD. So there's no like I don't understand why she is so against me and lets me out. I just don't get it. Like, I don't see what I'm doing that's so wrong. And every time that there is something, I make sure it's addressed. Like I said, even if I don't go to her specifically, like with the apartment being dirty, I take care of it myself. With the stuff out of the back patio, we might just not discuss it, but I made sure it was addressed. Like, I don't just leave her hanging and not take care of the things that she's got a problem with. I make sure I take care of them. The lighter fluid, the gas can, as soon as she mentioned them, I put them in my Jeep and transported it all the way to Blamewell. Like, I am trying my hardest to make things work with her. I feel like there's multiple people there that have bigger issues that are doing worse things that I could even possibly imagine doing. And I'm not one of them. I feel like I'm just so quiet. It's just me and my child. And occasionally my nieces. My sister has 2 kids.
And your brother, and your sisters, and your mother.
My mother was there. Yes, that was back in June. And we had, like I said, she come over, she watched me cry. She held my hand even. And we addressed that. With my brother, she held onto my child while I went and parked my car, and then I went into her office and we discussed it after that. She listened to me. She let me cry and vent to her. And then with my other brother, I have no clue because he's never even around and we don't even get along.
Well, we're not talking about the one that's not there. We're talking about the one that is there. So, all right, anything else?
No.
You're looking for possession only.
possession only, Your Honor.
Well, I don't have a basis to deny. I mean, sometimes the specific violations, and I'll agree the violations identified herein are not something that would raise the eyebrows a great deal, but this, except I gotta tell you, one that is certainly significant is, the repeated circumstances of unauthorized individuals residing there. But then we have unattended children. You may not have a problem with people, children being unattended, and other people's children being unattended may not be a concern. But the people or the children that are a concern or within your ward or control, that is something you should be concerned about because that creates liability issues, not only for you, but for potentially the property community. You didn't really even address the issue pertaining to the dog and the fire, both of which can be safety concerns also for the property. It's none of these necessarily jump out as something like, oh my gosh, we need to have you out. But you put it all together, it gets to be a fairly significant tone of issues and ongoing circumstances that just make this relationship, as counsel, in my opinion, rightly put it, that it just sounds like the relationship between the two parties here has come to an end, and it would be in everybody's best interest for you to vacate this premises. I will enter a judgment for possession. I will identify a possession date for you to be out on or before January 26th. This means that on January 27th, they have an ability to proceed further if you're not gone. All right, so you're going to have up through that weekend. I'm extending the time. I'm giving you twice the time that you would normally have to make arrangements, get some assistance, and move. All right, quite
Heather
frankly.
will tell you how hard it was for me to get the assistance for this.
Okay.
Like, I busted my
But-
butt, she said.
And
we
that
were,
and that
like,
may
really
and that may
close
well
to
be, and I sympathize with that. I don't enjoy doing this. Do you think that this is something I enjoy doing? Yes, I do not. Yet you came here, you presented a case that provided me with no options. You didn't give me an option. So
I've been to court before and I have, and I've been told, I mean, not in this case, but I've been to court before. I've had my own situations where I felt like there was gonna be a date where you guys would say, do you feel like you need proper representation? And I would have said yes.
when you have a matter set for a bench trial, that's a trial date. And this is not a criminal matter, so you're not going to get a court-appointed
I
attorney.
have no idea. I had no idea with that. None.
You didn't realize this wasn't a criminal matter?
I don't understand none of this. No, I don't. I really don't.
All right, I'll share with you. It's not a criminal matter.
So there's no right to an appeal on this.
No, there's a right to an appeal. You have a right to appeal. You're going to get once the judgment comes through, you're going to see on that judgment, you're going to have time frame for appeal. It's going to be right on that judgment, right on that.
Your Honor, I'd like to add something to the judgment. My client has indicated that if the defendant vacates timely by January 26th, and that means turning in the keys, then we would stipulate to setting aside this judgment and dismissing the case, which the implications of this are to preserve her LIHTC property so that she doesn't lose the status. So basically, my client indicated that if they were to contact her, she would give a neutral reference. It wouldn't indicate anything that would adversely affect her.
So we can do this differently then. We can do this by way of conditional dismissal. All right? Now, I want you to listen, because this is an opportunity that frankly, I wasn't expecting it to come out this way. So this gives you a very significant benefit. If they do a conditional dismissal and that condition of the dismissal is for you to be out by the 26th, if you're out by the 26th, the case is going to be dismissed. You don't have a judgment against you.
It won't be on a record.
Well, there won't be a judgment. It's not on a record. There will be no judgment. But if you're not, they have a right to file an affidavit indicating that you violated the condition of dismissal, and an automatic judgment will enter.
And I have actually, when all this first started, I called the person that got me in from OnPoint. And she said either way, it would not make a difference because the new tenants are gonna wanna know why I was evicted from this place. They're
That
gonna
new
wanna know
tenants
why-
have nothing to do with you. Has
Or
no-
the new property, whoever rents to me next is through HUD is gonna wonder why I broke the lease from this place. So she said it's gonna look really bad either way.
It would be, Your Honor, it would be a voluntary move. She would have to consent to it, obviously, for it to be a conditional dismissal, and there's nothing in it that indicates that you are past due or that you have all, it would be a voluntary move.
I guess you're gonna have to, you obviously sought enough advice to find that out. I don't understand why you didn't have any, or did you seek other advice and people told you that there was no defense? The problem here that I'm worried about here is we got two different stories coming here, and they're right now bending rather significantly to give you the opportunity to tell wherever you go to next that I just decided that was not a good fit for us, and they let me leave, and I chose to take that advantage of that. But you don't have a judgment. If they question further than that, that's outside their control. It's outside my control. It's even outside your control. But frankly, it's going to be your story to tell. It's going to be, as you indicated, a voluntary termination on both parties. So, but I can't force you. If you want a judgment that enters today, we'll do that. But I think it is, I would suggest to you that it would be to your advantage to have a conditional dismissal, but I can't force that. That's up to you.
So just to clarify, it would be a conditional dismissal with box 4B. It would indicate that you have until January 26, 2025 to clear your belongings, vacate the property, and turn the keys into the plaintiff. And then additionally, it would say that we would give you a neutral reference. If requested, neutral reference, the implications of that is that if somebody were to call, they would ask, was this person a resident here? Yes, she was. And that is all the information that they would give. They wouldn't give any additional information of any violations. It's a dismissal predicated on certain conditions being met. If you meet those conditions, this gets dismissed. So I don't see how that would adversely affect your LIHTC or anything.
Well, I mean, I don't know about whether it adversely or not, but it certainly is more beneficial than a judgment. But in any event, I can't force that. You can only, and we've got two more cases to hear. So I need to have it. How do you wish this to be done?
So if I file that, or if I go that route, I can't do the appeal.
You'd be agreed to a dismissal.
To a dismissal. I don't know which one, I really don't know what I should do. Like, I feel like I should represent myself. I feel like I should not be answering the question on my own. I don't have anywhere to go. Like, that's the.
You can submit it as a judgment.
Okay. So this is hearing judgment for January 26th for date.
What's that?
January 26th for date.
If you have it submitted to me today, it's.
I can have this.
All right, well, there it is. All right.
Okay, approve.
Yep. You're sure you want this as a judgment?
I really don't know what I should do. I feel like it's.
Cassie, I'm telling you right now, you're better off having a conditional dismissal. One, I can't, per my Premier property, I can't tell them why you left. Even if it was a judgment, I still cannot tell someone why you left. I can tell them the date you rented and if I would re-rent, and it doesn't matter who it is, it's always if qualified. If you take this judgment, it sits on your record and it will affect you. I'm not trying to do that.
Unless I agree to set it aside and dismiss it upon satisfaction.
Right, if you take the dismissal,
But
it's
you
gone.
but you still have a judgment on the record. It's been dismissed.
But it shows as a dismissal and it's not gonna affect you.
I just want to come to an agreement with you, Heather.
That's the only agreement I can
Like,
come
we
with.
have been okay
All right,
from the beginning.
I've got to get to my other trials. Ma'am, do you want this? You want a conditional dismissal? Do you want the
I don't even know.
judgment enters?
Exhibits, Judge.
I'm returning the exhibits to the plaintiff.
All right, that was 30 minutes for a case that should have lasted 3 minutes, but she just kept going and going, and I thought that was worth showing. Thank you so much for all the biggin raters. I didn't get a chance to. This case has been lasting forever, so thank you everybody for coming over. Thank you for joining the show. We got Judge Simpson one next. It was from a few days ago. I just noticed it today whenever I was going through some old video. It's either the 16th or the 17th. Judge Simpson had a protester in there, and it had a high dollar. I think it was a deputy attorney general being the prosecutor on it. So that was kind of interesting to see. So here we go with Judge Simpson.
Good afternoon, Your Honor. Benita Hoffman, Assistant Attorney General on behalf of the people.
Thank you. Good afternoon, Your Honor. Good afternoon to your staff. My name is Amir Macklett. I represent Ms. Samantha Lewis, whose president is standing to my right.
State your name, please.
Samantha Lewis.
Thank you. All right. This is an arraignment on two charges. One, resisting and obstructing and assaulting a police officer, and a charge of to carry along a trespass. Counsel, do you wish a formal reading of the complaint, or do you?
Thank you. Respectfully, Judge, I'd ask the court to waive the formal reading of the complaint. Ms. Lewis understands the charges before her and will stand mute to both counts.
All right. Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to both counts. I will set this for a probable cause conference. And typically, as you know, our practice, we set the probable cause conference and then the exam comes along. So I won't be giving you an exam date. But I guess here's my question. I currently have the other matters that are set for exam February 12th, correct?
That's correct.
All right. So is this going to be something that is separate from those? Or
Yes, they're different days.
Yes.
It's a different protest. So different facts, different witnesses.
different days? Okay.
It's still the same, essentially the same witnesses. It's the U of M Police Department. But yeah, there are separate facts and separate dates.
Separate officers even.
There? I don't know. Oh, well, here's what I was just trying to figure out. Does it make sense to set this for, I'll set it for a PCC, but is this going to, is it likely that this would end up on the 12th or not?
I don't think we'll have an exam on the 12th for this particular case, not with as many co-defendants as we have on the other case. I think that exam will run for, quite a while, just because there's 5 or 6 co-defendants.
I'm aware of it, but what I'm saying is it going to make sense because of the nature of the activities to put them all together? I'm not so much concerned about the witnesses, but one of the things I'm concerned about is Ms. Lewis coming here. She'd have to come for a PCC on this, then come back for the exam on the other matter. And I just, I'm just looking to try to make it as convenient as I can for everyone, but, if nobody wants to do that, I won't.
On the 12th.
Pardon?
We'll waive the 21-day rule, set the PCC on the 12th. That way the other.
That's a special date that I've set for the exam because I've got, I think, 8 co-defendants, so.
I'm at your discretion, Your Honor.
Well, I can just set this in the normal course, but I don't know if that inconveniences everyone in terms of doing it. That's all I was trying to do. I mean, I don't have to try to be nice about it, but I'm trying.
If we could set it, let's keep the 12th date if we can, Judge. I think that helps because I know my calendar is clear on the 12th. I know.
Well, the 12th will happen.
Right.
Where do you want me to put this case? That's what I'm asking.
We could, if it's the same witnesses, let's put it on the 12th, maybe right after.
For an exam, or you want a PCC before it and then make a determination as to we put it to the 12th?
Sure.
Would that make sense, Madam Attorney General?
Yes, I think that's fine.
All right, so what I'll do is I'll just set a probable cause conference in this case I can do a probable cause next week on the 23rd, if that works.
If we could have it in the afternoon, it would work for me, Judge.
If you'll give me one moment, I'll check my schedule, Your Honor.
Okay. I'm here all day, so I'm good.
Yes, the 23rd. I have a sentencing in 15th District Court at 2 p.m.
No way. No, I'm kidding. Okay, you have a sentencing at 2 in the afternoon at 15 on that.
Yes, in front of Judge Valvo.
Got it.
It's on another co-defendant. No, not a co-defendant, excuse me, another protester.
Got it. And you need the afternoon.
That's correct.
We have a 12:30 block. Yeah. Okay. then, okay, here's what I'll do then. I'll set a probable cause conference for January 23rd, 2025 at 12:30. Timelines having been waived, then we'll figure out, after looking at everything, where this one will go from there. All right. Any issues regarding bond on this case?
Your Honor, with respect to bond, we are asking that you not have any contact with the University of Michigan's properties or any of the University of Michigan property or students except as necessary for medical care. We're asking that you refrain from any assaultive conduct. We're asking that you not have any contact with the Tahrir Coalition, which is an organization.
I'm sorry.
Tahrir, TAHRIR Coalition.
Okay.
And that you not have any contact with Alice Elliott or Josiah Walker.
Assuming a recommendation of PR bond.
Oh, yes.
All right, everybody, the Tahrir Coalition at the University of Michigan. Tahrir is a student-led movement advocating for divestment from and boycott of settler colonization, occupation, mass incarceration, apartheid, and genocide. Seemed like a busy bunch. It seems like she would be with that group, not, maybe that's why they don't want her to have any connection with it. So, thank goodness for college. Here we go.
That's fine.
And it's Josiah, you said Walker?
Yes, Your Honor.
Counsel, any
Yes.
response to the condition request?
We don't object to personal recognizance bond, Judge. Ms. Lewis obviously has ties to the community and substantial support as evidence in the courtroom. I do have a strong objection to any prior restraint to this coalition or organizing or being a member or associated with the Tahrir Coalition. I don't know what the Tahrir Coalition is. It, according to the Attorney General in my conversation with her, she says it's a group that protests. Well, I don't think that the court rule 6.106 has any condition that would impose a prior restraint when it comes to bond. It's a
Well, that's not true, counsel. I mean, I heard this argument when I was reviewing the bond. Many times bond is about prior restraint, if you're going to look at the definition of prior restraint. So, I mean, I don't know that that is a compelling argument for the court.
Well, I think the association it's another right that an individual has, a citizen has the right to associate, to organize, and to have meetings with other individuals. This coalition, whatever the coalition stands for, does, or whatever activity they do, I don't think it's necessary as a condition of her bond. I think that it becomes an imposition that is not, it's a set of standards that doesn't happen in any other case. This is a situation, it's not part of her bond condition in the other case that we have pending before this court. I don't have an objection to not going to the University of Michigan except for medical purposes. No problem there.
Let me just ask this. Is she a student at the university?
No, not current.
Okay. So let me also then, I guess, ask the question, would there be any reason, so there's no reason that she would need to go to the University of Michigan except if it were
for medical
purposes along those lines, right?
Correct. That's correct.
Okay. I see that her address is a Detroit address.
That's correct.
That's correct. Okay. So is there any reason that she would need to be in Washtenaw County? And I'll tell you why I'm asking that. It may seem broad, but I also don't believe in placing individuals in positions where they may violate a condition of bond and not now. If it were easy, even for those of us that reside in this county, to figure out exactly where University of Michigan property is, then I wouldn't have a problem. But you could be walking along and all of a sudden she could find herself on U of M property not necessarily meaning to, but then in at least technical language violating the bond condition. So I try to set parameters that may seem rather restrictive, but also are clear for defendants. And one of the other things certainly let you talk. The other thing is I could not do, for example, I can't say Ann Arbor because University of Michigan properties exist within Washington County, outside of the city of Ann Arbor.
Well, Judge, there's campuses in Flint, there's campuses in Dearborn, there's.
No, I know,
Yeah.
but I'm more worried about here right now. I can't. My wonderful colleagues around the state can worry about those other places. I just have to worry about here. So,
Judge, she has ties to Washtenaw County. If the court's thinking about imposing that, she does have ties to Washtenaw. So I don't know where the court would like to go in terms of imposing a no contact order with the county of Washtenaw. She has ties here. Familial ties, personal ties, friendship ties, work associated ties.
all right, there's going to have to be some information given to the court about this. Is it Tahir Coalition?
So you're
I
on
don't. Go ahead.
the information that we have in our files is that the Tahrir Coalition is a professional organizing group that advocates for pro-Palestinian policies. And we don't have a problem with the fact that it exists or that it advocates, but Ms. Lewis's involvement with that group has so far resulted in 2 arrests for her that have resulted in charges for resisting and opposing a police officer. And for that reason, we're concerned about the contact that she has with them and the work that she does on their behalf, because it is leading to that kind of assaultive behavior.
Judge,
But are you indicating that her connection to the group, that she somehow is causing others in the group to act in a certain way, or that by her being part of the group, she's now acting in a certain way? I guess I'm unclear as to that.
Sure, Your Honor. I don't know if the group is causing her or if she's causing the members of the group to behave the way that they're behaving. But at the last case, the juvenile was arrested for resisting and opposing as well. We elected not to charge her, but there was a juvenile that was involved in this particular protest. She was sort of the ringleader. She was the one that had the loudspeaker. She spoke over the officer who was trying to get the people to disperse and put down signs that they had pointed edges on the sticks. And then she resisted the police officers when they went to arrest her. So our position on it is, I don't know if she's the cause or if she's caused, but either way, she's behaving inappropriately. If she was just speaking, no problem.
Right, but outside of the behavior that different sides may disagree on, I'm trying to figure out what the correlation is between the behavior that is alleged and her participation or alleged participation with this group or coalition. I'm not following it, I guess.
Your Honor, I understand the court's concerns, and in light of the fact that she could do work with the organization, I would rephrase my request to be that she not be involved in any protests with the organization.
Gotcha. Judge, we're not coming to camp.
Hold on before you go, because I'm sure you've got a lot to say on that.
I do.
Yeah. Well, again, maybe you have to help me here. Is it this Tahir Coalition that is responsible for the protest? Is that the piece I'm missing?
That's what we believe to be the case, Your Honor.
And so, again, so that I'm clear, that the Tahir Coalition is alleged, or at least thought to be responsible for the protest. And so you want to restrict this individual's participation with that group because of their responsibility for organizing the protests that have led to this.
That's correct.
Okay. I at least understand their position. Maybe I agree, don't agree, but go ahead.
Very well. Thank you, Judge. Respectfully. The defense, and the court is no surprise, the defense is this is free speech, that these are protests, and that this is indicated that she's presumed innocent until proven guilty from the very outrageous, ridiculous, and with no merit to the charges that she's brought now twice. Okay, this is going to be very litigated. Her position is that she's not guilty and that she's going to be presumed innocent until proven guilty. The bond conditions, Judge, are supposed to be set so that somebody comes before this court and that there's community safety and other provisions that we've already accomplished one provision of safety for the community. She's not going back to campus. Nothing associated with the University of Michigan. We agree. The further condition of association with Tahrir Coalition, whether or not they're the reason for this group that organized this protest or not, that's, to me, I don't think that they are. I think that the reason why these protests occurred is because the genocide that was happening in Gaza. So whether it's Tahrir organization, Students for Justice in Palestine, any other of the dozens and dozens of groups that are standing and against what the purpose of that protest, they could have been associated with as well, with these protests. You can't just pick one group and say, you can't be a part of that because we believe with no evidence. It's just it's a summarily stated statement by the AG at this point that she can't associate with it. It doesn't have any reason or purpose in a bond condition. It's not necessary. We're not going to campus. We're not going to have any more protests. She's not protesting. There's a ceasefire, thankfully, that we've heard of. So I think that the situation has calmed down a bit. However, it's unnecessary at this point, Judge. And 6.106 it's not required. When we get to the other issues of no contact with the co-defendants, Judge, we have joint defense agreements in this case in the other case. I don't know if we're going to do the same in this case, but the lawyers will be communicating. And there is going to be time when our clients are going to be in rooms with the co-defendants while we're communicating defense in this case. I'm letting the court know that from now. We've been in talks, and we're going to continue to talk to defend our clients. So outside of that, no problem. We're not going to have contact. But I just want to make the court aware that there are joint defenses in this case.
I understand that, and I don't think the court's order would in any way be interpreted to cover the scenario that you're indicating.
Thank you, Judge.
I mean, I don't think it could. So that's the first part of that. The other part, though, is anything else from either side?
No
Your
further,
Honor,
Judge.
I didn't hear the last thing that the court said. I'm sorry.
I said, was there anything else from either side?
No, Your Honor.
All right. I will indicate that I'll set the defendant's bond at $10,000 personal or cognizance bond. She's not to leave the state of Michigan without permission of the court. She's not to commit any crimes, she is not to commit any crimes. She's immediately notify the court of any change of address. She is not to use any illegal substances. She is not to purchase, possess, or any firearms, ammunition, or anything fashioned to be a weapon. I think that it's too broad regarding the request. Well, there are two real issues here. One being the Tahrir Coalition. Without more, this court would have some concern with restricting someone from talking to a particular group. I am not familiar with the Tahrir Coalition, but if, for example, that coalition, and again, I don't know, if they have certain different arms of that coalition that do different things, and she might be involved with the humanitarian effort within that, and it would seem improper for the court to stop her from being able to engage in that. So, and so without knowing more, I am going to decline to put a prohibition on the defendant that she could not have contact with the Tahir Coalition. By the same token, as I kind of was signaling and would indicate, that except for court-related proceedings and other things, I am going to indicate that the defendant is not to be in Washtenaw County. I don't see a basis or need for her to be here. She has to visit friends. She has to make certain other arrangements that will. Counsel, you may want to.
And she.
Counsel, you may want to mute when you if she's stuck. I just wanted to.
I'm sorry.
Go ahead. You can finish your question.
Judge, I need to approach, but I don't know how we're going to accomplish that with the AG on Zoom.
Because I'm the master of Zoom, and we will.
If I may approach, Your Honor.
Pardon? Oh, you need to let go. Oh.
I did. I just let go. I need to approach. Just.
All right. Here's what we'll do. Ma'am, you can have a C. Take him yes, and then.
Thank you, Judge.
And for the rest of you here, we'll get you home in time for dinner, maybe.
Wherever she
Get yourself a seat. All right.
All right, that pretty much brings it to the end of that one. Hold on a second. Let me see there. We've got one more we're gonna do with Judge Magistrate Court in Detroit. Let's play that one out, and that'll be the last one for tonight. So,
This is case 25-055219, State of Michigan versus Terry Maurice Allen, counsel.
Samuel A. Ragnan for the people, Your Honor.
Yes, Your Honor. Brendan Bird on behalf of Terry Allen. Mr. Allen waives his right to formal reading, was advised his constitutional rights, and will stand mute.
Court will enter not guilty plea on your client's behalf as to bond.
Well, yeah, the people are asking for $50,000 personal bond, but we're asking for two things. We're asking for an alcohol tether, and we're also asking for a tether with home arrest. First of all, he was caught again for driving under the influence, and he fled from the police twice and driving fast through neighborhoods and disregarding traffic signals, which cause a great danger to the community and to the police. But I believe, Your Honor, that he also has at least 4 previous convictions for operating third offense. While operating impaired back on 12/15/14, and then 3 of them on December 15th, 2014. Also got attempt receiving concealing stolen property, but with the number, and he has no license. His license has been revoked, at least from my understanding, for quite some time, but he keeps driving his vehicle, and then he speeds away from the police, which I think is a danger. So I think definitely needs an alcohol tether, and I think a tether with home arrest is most important. Thank you.
Thank you.
What's confusing to me about his previous criminal history that's on the complaint, Your Honor, is we have 3 different operating while intoxicated on the same day. Now, I'm not sure if those are 3 different cases, but I don't see how he would have 3 of those on the same, 3 different ones on the same day, if they're not just 3 completely different cases. But another thing, Your Honor, my client wasn't charging with fleeing. The prosecution has the ability to bring those charges. They had the ability to bring those charges after analyzing the evidence, and he's not being charged with fleeing. He's being charged with his OWI third. He's a 45-year-old lifelong resident of Michigan, Your Honor, indicates to us that he has one child. He is employed. He's been there for about 3 years now. We have been
for 14 years.
14 years. Sorry, thank you. 14 years, Your Honor. And I got confused. He works 3 p.m. to 2 a.m. For 14 years. He went to trade school. He's in the labor union. He went to trade school and college. Indicates to us there's no amount of bond that he could afford at this time. Now, I do understand this is operating while intoxicated, third offense notice. It is non-assaultive in nature. Respectfully, we're not gonna be objecting to the personal bond. I don't really see a reason for a GPS tether on him. We haven't been presented with anything that makes him a threat to the community. And even if we are going by his last OWI charges, that was in 2014, roughly over 11 years ago. Respectfully, Your Honor, we're going to not object to that personal bond. We're going to ask for no tether at all. But if this court is inclined to give him an alcohol tether, then we would ask, could he be able to turn himself in within 24 hours to receive that tether so he doesn't lose his job and he can still support his family like he's been doing for the past years, Your Honor.
Thank you. Defendant has quite a history of drunk driving. There is some confusion with regard to these 3 priors, all listed on the same day. And court is as confused as defense counsel as to whether or not those are 3 separate cases or what. But being that they are third offenses, that makes this at least his 4th offense, if not at least his 6th offense. So you got to get your drinking under control. It's as simple as that. While this case is pending, you are not to consume alcohol at any time. You will have an alcohol tether. You will also have a GPS tether. You go to work only on that tether. You are not to drive without a valid license.
Yes, sir. I can't wear 2 tethers. How do I wear 2 tethers?
You got 2 ankles, sir. You got 2 ankles, right? All right. Court will set bond at $20,000 personal. Next court date is probable cause conference, January 22, preliminary exam, January 29, both in front of Judge Giles here in 36th District Court. Thank you, sir. You can step aside.
Permission to speak, Your Honor.
I have one question, sir.
One moment, Mr. Allen. One moment. Mr. Allen, one moment, please. One moment. Your Honor, respectfully, we're just asking, can he please turn himself in for those tethers? He's not trying to run from this situation. He's gonna end up losing his job.
With the drunk driving record that he has, I am not comfortable with him turning himself in. He'll have to get those tethers before he's released.
I'm gonna get fired. They don't do the tethers for 2 or 3 weeks because of your system down here with the new jail. I'm gonna get fired. I'm gonna be pointless. I won't be able to afford to try to lose my house.
Sir, last I heard on the wait time for tethers, which was about a week or 2 ago, it was a day and a half.
No, it's not. They just told Action Deputy. They just said it takes a week, 2 weeks before you can get down there and get you a tether. I will be fired from Chrysler. I have a $900 mortgage on my house. I will lose my mortgage. I have bills. There's nothing else I can say. I have to go to work. I can turn myself in tomorrow and put a tether on, no problem. I have to be able to show.
I don't know why the judge doesn't understand he's got to go to work so he can afford his alcohol so he can get another DUI. It doesn't make sense. But I know that'd be an expensive tethers. Those things are about $100 a week, so that's $200, that's $800 a month. The dang car payment on his ankles.
To work or I'm fired. You get 4 days. And that's it.
Mr. Byrd, you want to address that?
No 3 days, no 3 drunk drivers in 1 day. That's impossible.
Mr. Allen, We tried. Unfortunately, the judge isn't allowing you to turn yourself in. Hopefully.
Been in trouble with drinking and driving in 10 years. What are you talking about? It's 2025 to 2011. It was longer than that. It was the last one, 2014, 13.
Mr. Allen, I explained all this to the judge.
If I don't show up, you can arrest me, fry me, keep me, then I let me get fired. But at least give me a chance to keep my job. That's all I'm asking. Just give me a chance to keep my job. Let me show you that I can do this. It's no problem. If I violate, you got me. If I don't, I can prove it to you. Just let me show up to get my job. Boom. I can show up in 48 hours to both places, get whatever you need, paperwork, documents, show them that I'm doing it, show you I'm doing it. I can come down to your courtroom and show you I'm doing it. However you need me to do it. But don't let me lose my job. This ain't McDonald's. That's all I got.
Sir, I'm very, what's the word? I mean, I'm not trying to make you lose your job, but I also have a requirement to protect the public.
Protect the public from what? I wasn't drinking.
Mr. Allen, one moment. Your Honor, we haven't been presented with any evidence that he broke any bond conditions in the past. We haven't been presented any evidence that he violated probation or violated any order the court has gave him after he had caught these cases, after he had caught any of those cases.
Not one.
He does have driving while license suspended tickets also during this time frame, and so I
never left the crime, never left a scene of anything.
Please, Mr. Allen, please just hold on one moment. I do understand your frustration, but just hold on one moment.
Mr. Ragnow, can you address these three priors on the same date in 2014?
Yeah, I can for sure. What I was able to find, if I looked at that as well, is that he pled guilty to driving on third offense, OWI third offense, and he also pled guilty to OWI not third offense. Those are the two charges that I have saw on the PBK on the list of offenses of this defendant and convictions,
which wouldn't show up as as conviction.
But I have a previous. Excuse me, I wasn't done. That's okay. We have impaired on 5/14/09 as well, Your Honor. Plus, we have at least two convictions on the 14th that I verified, and then now we have an OWI 3rd again. So this would be at least the 4th at the minimum, but it could be also the 5th. I wasn't able to get any more information.
He's repeating the same one over and over. It's impossible to have two DUIs or OWIs on the same day. He knows
two separate charges.
Mr. Allen, please.
Two separate charges, I believe.
Your Honor?
It was not.
Yes, Ms. Coyle.
Lisa Coyle, appearing on behalf of the people, Your Honor. I'm looking at the Register of Actions out of Third Circuit. It looks like they have on the CCH different arrest dates. I see case number 14-4349. I'm going to pull it up and talk. He was sentenced on December 15th, 14 for OWI 3rd before Judge Lillard. Then on case number 14-10500, that's an OWI 3rd. He also was sentenced on a separate case for 12-15-14 before Judge Lillard at OWI, and it was charged third offense notice. My guess is he pled on both felonies. Probably one was charged high BAC at the time. I'm just looking quickly, but 2 counts of OWI on that 14 case. And then he was also convicted on 18-1020. And that case, Your Honor, he was sentenced before the Honorable Judge Ramsey on February 19th of 19. And he got 2 years probation for OWI third. And he was discharged in 21 on that last case, Your Honor. So that's probably why he had multiple cases running, and Judge Lillard did 2 of them. And then a couple of years later, in 2018, or what did I say, 2019, then he was sentenced before Judge Ramsey.
Thank you, Ms. Clay.
So he's at least 3 felonies. I think the information, the complaint is somewhat inaccurate, but the conviction dates are, I can run them also in Otis.
He has a conviction on 5.
All right, here's what we're gonna do. Here's what we're
2009 as well.
Thank you.
Thank you, Ms. Coyle.
Yes, thank you, Ms. Coyle. I will drop the GPS tether. There still will be a alcohol tether, and that has to be put on before he leaves detention. Bond is
Sir,
still
that's not a problem. The
$20,000.
only problem is I'm gonna get fired.
The alcohol tethers come a lot quicker, and that's why he did that for. That's why he did that for you, Mr. Allen.
No, they do not. They're not. He just told me, did you tell him, please, that you don't come? He just made a big speech to us that the alcohol tether, because of the tether, anybody that gets a tether, alcohol tether, regular tether, anybody getting a tether because they just moved to the new building downtown, that it will take at least 5 to 10 business days to get this tether. Did you not tell me, sir? I'm talking to your officer. Did you not tell me that, sir? He just had a speech from everybody.
All right, thank you, sir. You're all set.
So I thought about something with this case. You know, everybody's fussing about the defendant talking and how he should shut up. In reality, he's probably been in court more than the magistrate or the attorney. So there again, he's probably got more experience than all of them. So you guys have a great night, and we'll see y'all. We're going to do tomorrow morning about 9:30. We're going to start up and see if we can't wait on Judge Fleischer in the morning. So we'll see you there.